Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain the eviction laws in Georgia and outline some simple steps that landlords can take to initiate an eviction. First, what is an eviction? An eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks on a property or physically remove a tenant from that property. So, if the tenant refuses to leave after violating the terms of a lease agreement, a landlord must seek an eviction from the court. This is different from the simple termination of a lease. A landlord can opt not to renew a lease after the specified term has ended. There is no need to involve the court in this process. In this video, we'll talk about what the eviction process looks like, Georgia laws that determine how evictions are handled, and how to legally remove a non-compliant tenant from a property. Be sure to watch to the end of this video to find a link to a fillable eviction notice. When a tenant commits a lease violation in Georgia, the landlord can serve the tenant with a form known as an immediate notice to quit. This instructs the tenant to either immediately address and rectify the issue, whether that's the failure to pay rent or some other violation, or face eviction. Many states allow the tenant a certain number of days in which to fix the identified problem, but in Georgia, the notice to quit requires immediate action. Another form, called a 30-day notice to quit, is used to end a month-to-month lease in the state of Georgia. If a landlord issues this notice, it must be issued 60 days in advance. If a tenant is not choosing to renew a month-to-month tenancy in Georgia, notice can be given 30 days in advance. This form does not have to be associated with a lease violation. If the tenant fails to respond to the notice to quit, the landlord can then obtain what is known as a dispossessory affidavit from the local magistrate court. The affidavit will ask for such information as the tenant's name and address, the reason for the eviction, and proof that the tenant was served with a notice to quit. The best way to offer this proof is to send the notice via certified mail or a process server. The dispossessory affidavit will then be served on the tenant by a sheriff or process server. After receiving this document, the tenant will have 7 days to respond using what's called an answer form. This form can be found on our website. The answer form asks the tenant to explain the grounds for challenging the suit. If the tenant does not respond, the landlord can obtain what's known as a writ of possession. This can be filed with the court. Once signed by a clerk, a writ of possession authorizes a sheriff to remove the tenant and the tenant's possessions from the landlord's property. We've got everything you need to get eviction proceedings going, from eviction notices to court documents, and you can access all of them at the link below for free.